California Civil Procedure Handbook rules, selected statutes and cases, and comparative analysis. Chapter 8, Trial and Post-Trial Motions. Subpart 2, B, Trial by Jury. Section 5, Jury Verdicts. Non-unanimous verdicts. The jury in a civil case must consist of 12 persons, unless the parties agree upon a lesser number, but may consist of 8 persons in a limited civil case if the legislature so provides, or a lesser number if agreed upon by the parties. California Constitution, Article 1, Section 16. The California Constitution does not require unanimous jury in civil cases. A verdict rendered by 3/4 of the jury is permitted. This is also supported by, outside of the Constitution, also CCP Section 618. Prior to our Resch v. Volkswagen of America, Inc. of 1984, the same 9 jurors had to agree on all elements of the ultimate verdict when returning special verdicts. See Earl v. Times Mirko of 1921. The Resch court repudiated this identical 9 rule and requires only that any 9 jurors agree on each special verdict comprising the ultimate verdict. General verdicts versus special verdicts. The verdict of a jury must be either general or a special verdict. CCP 624. Unlike a general verdict, which merely implies findings on all issues in favor of the plaintiff or defendant, a special verdict presents to the jury each ultimate fact in the case. Falls v. Superior Court of 1987. The jury must resolve all of the ultimate facts presented to it in the special verdict, so that nothing shall remain to the court but to draw from them conclusions of law. Section 624. When special verdicts are recommended or required, generally the decision whether to submit a general verdict or special verdict to the jury is entirely in the discretion of the trial court. CCP 625, Halibert v. Sonora Community Hospital, 1989. Stone v. Foster, 1980. Use of special verdicts is required by CCP Section 625, however, in all cases in which issues of punitive damages are presented to the jury, so that findings of punitive damages are separate from compensatory damages. Use of special verdicts or of a general verdict accompanied by special findings may be necessary in other situations. See Gorman v. Leftwich of 1990, in which the trial court abused its discretion by refusing to use requested special verdict forms with respect to calculation of past and future damages by the jury in a medical malpractice case where the case involved the possibility of substantial future damages, which under CCP 667.7 must be paid periodically and not in a lump sum. Daly v. General Motors Corp. of 1978, recommending the use of special verdicts when jury is asked to apportion fault on a comparative basis. Now we've moved to subpart C, taking the case from the jury. 1. Nonsuit, directed verdict, and judgment notwithstanding the verdict. A defendant may move for a judgment of nonsuit upon completion of a plaintiff's opening statement or of the presentation of plaintiff's evidence in jury trial. CCP 581CA. If the motion is granted, the judgment on nonsuit operates as an adjudication on the merits unless the court specifies otherwise. 581CC. If the motion is denied, the defendant still has the right to offer evidence. 581CA. After all parties have completed the presentation of all their evidence in a jury trial, any party may move for an order directing entry of a verdict in its favor. Section 630A. Except for this difference in timing, a directed verdict is equivalent to a nonsuit. After a jury verdict, a judge or a party against whom the verdict was rendered may move for a judgment notwithstanding the verdict. CCP 629. The test for entering a nonsuit, directing a verdict, and granting a motion for judgment notwithstanding the verdict is the same as explained in Howder v. Zogerts, 1975. The trial judge's power to grant a judgment notwithstanding the verdict is identical to its power to grant a directed verdict. The trial judge cannot reweigh the evidence or judge the credibility of witnesses if the evidence is conflicting or in several reasonable inferences, or if several reasonable inferences may be drawn. The motion for judgment notwithstanding the verdict should be denied. A motion for judgment notwithstanding the verdict of a jury may properly be granted only if it appears from the evidence viewed in light most favorable to the parties securing the verdict that there is no substantial evidence to support the verdict. If there is any substantial evidence or reasonable inferences to be drawn therefrom in support of the verdict, the motion should be denied. Bradenburg v. Pack, Gas and Electric Co. 1946. 2. Motion for new trial. The most frequently employed post-trial motion is the motion for a new trial. If granted, a new trial order authorizes a de novo trial as if the first trial never occurred and permits a re-examination of an issue of fact in the same court after trial and decision by a jury, court, or a referee. CCP 656. The grounds and procedures for new trial motions are set forth in CCP section 657 through 663.2. Because the right to move for a new trial is a creature of statute, the procedural steps prescribed by these statutes must be followed. Linhart v. Nelson, 1976. The permissible grounds for a new trial are set forth in CCP 657, which is reproduced below. Grounds for a new trial, requisites of order granting new trial for insufficiency of evidence is what is the title of section 657. The verdict may be vacated and any other decision may be modified or vacated in whole or in part, and a new or further trial granted on all or part of the issues on the application of the party agreed for any of the following causes materially affecting the substantial rights of a party. 1. Irregularity in the proceeding of the court, jury, or adverse party, or any order of the court, or abuse of discretion by which either party was prevented from having a fair trial. 2. Misconduct of the jury, and whenever any one or more of the jurors have been induced to assent to any general or special verdict or to a finding on any question submitted to them by the court by a resort to the determination of chance, such misconduct may be proved by the affidavit of any one of the jurors. Accident or surprise, which ordinary prudence could have guarded against. Newly discovered evidence. This is 4. Material for the party making the application which he could not with reasonable diligence have discovered and produced at the trial. 5. Excessive or inadequate damages. 6. Insufficiency of the evidence to justify the verdict or other decision, or the verdict or other decision is against the law. 7. Error in law occurring at the trial and accepted to by the party making the application. When a new trial is granted on all or part of the issues, the court shall specify the ground or grounds upon which it is granted, and the court's reasons for granting the new trial upon each ground stated. A new trial shall not be granted upon the ground of insufficiency of the evidence to justify the verdict or other decision, nor upon the ground of excessive or inadequate damages, unless after weighing the evidence the court is convinced from the entire record, including reasonable inferences therefrom, that the court or jury clearly should have reached a different verdict or decision. The order passing upon in determining the motion must be made and entered as provided in section 660, and if the motion is granted, must state the ground or grounds relied upon by the court and may contain the specification of reasons. If an order granting such motion does not contain such specification of reasons, the court must within 10 days after filing such order prepare, sign, and file such specification for reasons in writing with the clerk. The court shall not direct the attorney for a party to prepare either or both said order and said specification of reasons. On appeal from an order granting a new trial, the order shall be affirmed if it should have been granted upon any ground stated in the motion, whether or not specified in the order or specification of reasons, except that A, the order shall not be affirmed upon the ground of the insufficiency of the evidence to justify the verdict or other decision, or upon the ground of excessive or inexcessive damages, unless each ground is stated in the order granting the motion, and B, on appeal from the order granting a new trial, upon the ground of the insufficiency of the evidence to justify the verdict or other decision, or upon the ground of excessive or inadequate damages, it shall be conclusively presumed that said order as to such ground was made only for the reasons specified in said order, or said specification of reasons in such order shall be reversed as to such ground only if there is no substantial basis in the record for any such reasons. Notes and questions regarding new trial motions. 1. Motion for new trial, statutory grounds, exclusive. Section 657 sets forth the exclusive grounds upon which a trial court may grant a new trial. Linhard v. Nelson of 1976. These enumerated grounds, which there were 7 of them that I read, both encompass both procedural errors, which is jury misconduct and other irregularities in the proceedings, and substantive errors such as insufficiency of the evidence, excessive damages, and error in law occurring during trial. A new trial may not be granted, of course, unless the error materially affects the substantial rights of the moving party. Materially affects the substantial rights of the moving party. In other words, in fact, actually, I should also highlight a lot of things in non-suit directed verdict and judgment notwithstanding the verdict. Honestly. Okay, so judgment notwithstanding the verdict, a JNOV, may properly be granted only if it appears from the evidence, viewed in light most favorable to the party securing the verdict, that there is no substantial evidence to support the verdict. Alright, that's all I'm getting from that. Alright, actually there's another one. It says here, unless after weighing evidence, the court is convinced from the entire record, including reasonable inferences therefrom, that the court or jury clearly should have reached a different verdict or decision. That's when a new trial should be granted. So, a standard for motion for a new trial is basically the court is convinced from the entire record, including reasonable inferences therefrom, that the court or jury clearly should have reached a different verdict or decision. And they actually have to write their own order, is what was said next. But when it comes to the non-suit directed verdict and judgment notwithstanding the verdict, they're trying to say that this Howder versus Zogerts considers them all to be essentially the same, and cites the standard, which I am going to say is JNOV, judgment notwithstanding the verdict, just one more time, is that it appears from the evidence viewed in light most favorable to the party securing the verdict that there is no substantial evidence to support the verdict. So, back to the note. We had said materially affects the substantial rights of the moving party. That's the standard in which a new trial may be granted. So it's not enough that from the entire that's like two different ways of saying it, which is what makes it so confusing. But we said just a second ago the motion for new trial is when the court is convinced from the entire record, including reasonable inferences therefrom, that the court or jury clearly should have reached a different verdict or decision, and that necessarily includes that this error materially affected the substantial rights of the moving party. In other words, unless the error, right, so here's the third different way to explain it, unless the error is prejudicial and not harmless. From California Constitution, Article 6, Section 13, no judgment shall be set aside or new trial granted unless after examination of the entire cause, including the evidence, the court shall be of the opinion that the error complained of has resulted in a miscarriage of justice. Is that really from the Constitution? The California Constitution? I mean, if it is, they're giving the citation before the quote, and that's not what I've been expecting this whole time I've been reading this entire book. So, next note on new trial motions. 2. Aggrieved party must file a motion for new trial. The Code of Civil Procedure, Section 657 and 660, impose limitations and requirements on motions for new trials. The power of the trial court to grant a new trial may be exercised only by the following statutory procedure and is conditioned upon the timely filing of a motion for new trial, the court being without power to order a new trial sua sponte. Alright, they can't order it sua sponte. That cannot be done. Alright. An aggrieved party must file a written notice of intention to move for a new trial within 15 days of the date of mailing the notice of entry of judgment by the clerk or by a party, or within 180 days after entry of the judgment, whichever is earliest. And that comes from the CCP 659 and Rule 3.1600 California Rules of Court. This notice must designate the grounds upon which the motion is made. Section 659. The motion for new trial can only be granted on a ground specified in the notice of intention to move for a new trial. This cites Malkasian v. Irwin of 1964, Wagner v. Singleton of 1982, order granting new trial on ground of misconduct of counsel held void when motion only specified ground of insufficiency of the evidence. Neal v. Montgomery Elevator Co. of 1992, a new trial was granted due to material error of law ruled procedurally proper, where error of law listed as one of the grounds in plaintiff's notice of motion, although not urged by plaintiff in moving papers or at oral argument. There's a lot of notes to this section. There's literally, I just finished reading note number 2, but there's literally 14 notes before we get to the next chapter. Okay, so note number 3. A new trial order must state grounds and specify reasons. If a motion for new trial is granted, CCP 657 requires the trial judge to state the grounds upon which the motion was granted in the new trial order, and to specify the reasons within 10 days after the order. A new order which does not state grounds or specify reasons is defective but not void. This quotes Sanchez Correa Supra. They cited that before and I just avoided it. What year is this Sanchez case? I've seen it before, but I can't find it now. Okay. Sanchez Korea versus Bank of America, 1985. Alright, so, under such circumstances, an appellate court is precluded by Section 657 from affirming the order on the grounds of insufficiency of the evidence or excessive damages. But see La Mana v. Stewart of 1975. Appellate court properly considered ground of insufficiency of evidence to justify verdict despite the trial court's failure to state any grounds for the new trial order, where a motion for new trial made solely on that one ground. This book's getting kind of sloppy toward the end. An appellate court is also precluded from considering any other ground not designated in the motion for new trial. CCP 657, see Neal Supra. Note 4, 60-day limit on trial court's power to decide motion. CCP 660 provides a pertinent part. The power of the court to rule on a motion for a new trial shall expire 60 days from and after the mailing of notice of entry of judgment by the court, or 60 days from and after service on the moving party by any party of written notice of the entry of judgment, whichever is earlier, or if such notice has not theretofore been given, then 60 days after filing of the first notice of intention to move for new trial. If such motion is not determined within said period of 60 days, the effect shall be a denial of the motion without further order of the court. A trial court lacks jurisdiction to decide a new trial motion after the 60-day limitation imposed by CCP 660, Seagal v. Superior Court of 1968. If no determination is made within the 60-day period, the motion is deemed to have been denied. A trial court also lacks jurisdiction to file a statement on grounds after the 60-day period, even though the trial court decided the motion within the 60-day period. That comes from the Sanchez-Correa case. Note 6. Motion and exercise of discretion. Regardless of whether the grounds asserted in support of the new trial motion will constitute procedural or substantive error, the determination of the motion is addressed in trial court's discretion. Romero v. Briggs of 1994. Abuse of discretion standard applied to new trial granted because of insufficiency of the evidence. Neal v. Farmers Insurance Exchange of 1978. Appellate court will not reverse a proper order granting a new trial on grounds of excessive damages or requiring reduction of the amount as a condition of denying one unless trial court clearly abuses discretion. Hand Electronics, Inc. v. Snowline Joint Unified School District. On appeal from an order granting a new trial because of misleading jury instruction, sole question is whether trial court abuses discretion. A new trial order will not be disturbed on appeal unless a manifest and unmistakable abuse of discretion clearly appears. So, these are the standards of review we were talking about. There were like 4 different kinds. So, a new trial order will not be disturbed on appeal unless a manifest and unmistakable abuse of discretion clearly appears. That's from the Jimenez or Sears Roebuck and Co. case of 1971. So long as a reasonable or even fairly debatable justification of the law is shown for an order granting a new trial, the order will not be set aside. Why is the determination of a new trial motion asserting grounds of substantial error a matter for the trial court's discretion? Should it be? In what sense is such a motion not a matter of trial court discretion? So basically, I'm granted a motion for a new trial, and the opposing party appeals. And on appeal, they're only going to say that the appeal court is only going to rule against the trial court determining that a new trial is warranted if there's a manifest and unmistakable abuse of discretion by the trial court ordering a new trial. And why is that standard so high? Because the trial court heard the case and they were present, whereas the appeal court is only reading the transcript and really can't infer any, prejudicial intonation or anything. And they really weren't there, like, in chambers or anything. They don't know what evidence wasn't presented, what arguments were had, what instructions were denied, things like that. Anyway, when a trial court determines a motion, okay, so this is note 7, insufficiency of evidence. When a trial court determines a motion for new trial made upon the ground of insufficiency of the evidence, CCP 657 requires the judge to weigh the evidence and judge the credibility of the witnesses. That's the answer to the earlier question. See Dominguez versus Pantalone of 1989. In so doing, the court may disbelieve witnesses and draw inferences contrary to those supporting the verdict. Loxley versus Ungureanu of 1986. Widener versus Pacific Gas and Electric Co. of 1977. The court may grant a new trial even though there is sufficient evidence to sustain the jury's verdict on appeal. Candido v. Hugh of 1984. Nonetheless, a new trial cannot be granted unless, after weighing the evidence, the court is convinced from the entire record, including the reasonable inferences therefrom, that the court or jury clearly should have reached a different verdict or decision. CCP 667. How is the standard a trial judge must employ when determining a new trial motion for insufficiency of the evidence under CCP 657 different from the standard applicable to a motion for judgment notwithstanding the verdict under CCP 629? Great question. See Fountain Valley Chateau Blanc Homeowners Association vs. Department of Veteran Affairs. Tell me the answer. 1998. Why are these two standards different? If a trial court grants a new trial motion for insufficiency of the evidence, must it also grant accompanying JNOV motion? If the court denies a party's new trial motion on the ground of insufficiency of the evidence, must it also deny that party's JNOV motion? Yes. No. I mean, I don't get the feel that somebody is going to motion for them both. I really get the feeling that the JNOV is happening during trial, maybe afterwards, and that would just be a decision. It wouldn't warrant a new trial at all. The motion for a new trial grants a new trial. So, I don't think JNOV needs a new trial. The judge just overrides the jury's verdict. But, I don't know. Spitballing. What is the standard applicable to appellate review of a trial court order granting a new trial on the basis of insufficient evidence to support the jury verdict? What is the standard applicable to appellate review of a trial court granting a new trial on the basis of insufficient evidence to support the jury verdict? The Supreme Court answered this question and several others with respect to new trial orders under CCP 67 in Lane v. Hughes Aircraft Co. of 2000. An order granting a new trial based on insufficiency of the evidence must be sustained on appeal unless the opposing party demonstrates for that no reasonable finder of fact could have found for the movement on the trial court's theory. The reason for this deference is that the trial court, in ruling on the new trial motion, sits as an independent trier of fact. Therefore, trial court's factual determinations reflected in its decision to grant a new trial are entitled to the same deference that an appellate court would ordinarily accord a jury's factual determinations. The Supreme Court emphasized that, so long as the outcome is uncertain at the close of trial, that is, so long as the evidence can support a verdict in favor of either party, a properly constructed new trial order is not subject to reversal on appeal. Note 8. Excessive damages and conditional new trial orders remitter. Section 657 also requires a trial judge to weigh the evidence and judge the credibility of witnesses when determining a motion for new trial based upon the ground of excessive or inadequate damages. In ruling on a motion for a new trial but excessive damages, the trial court does not sit in an appellate capacity but as an independent trier of fact. Neal v. Farmers Insurance Exchange, 1978. Trial court did not abuse discretion in granting new trial motion for excessive damages where the evidence bearing on damages issue was in substantial conflict. The trial court may, in its discretion, order a new trial limited to the issue of damages and may condition its order so that the motion is denied if the party in whose favor the verdict has been rendered consents to such reduction of damages as the court in the independent judgment determines from the evidence to be fair and reasonable. CCP 662.5. Such a conditional new trial procedure, commonly referred to as remitter, is expressly authorized by CCP 662.5b. CCP 2.5 authorizes the corresponding process of additure for inadequate damages, except I know that's not constitutional, so why are we talking about it? See Marshall v. Department of Water and Power. Jury award of $1 increased by means of additor to $100,001 after plaintiff moved for a new trial. Trial courts often utilize remitter when damages are properly awarded, but the amount is excessive, and a new trial can be avoided if the non-moving party consents to a reduction. See example Hansen v. Ford Motor Company. Trial court required plaintiff to consent to a $1.65 million reduction in damage award in order to avoid a new trial. Neal v. Farmers Insurance Exchange, Super, jury verdict of $1.5 million. Remitted to $750,000. Grimshaw v. Ford Motor Company, 1981. Trial court required plaintiff to remit all but $3.5 million of $125 million punitive damage verdict as a condition of denial of defendant's new trial motion. Go back to the editor. Tell me the editor is unconstitutional. Certainly in this state, I'm shocked that they're not talking about that. Note 9, newly discovered evidence in marriage of lieu. The court expressed the narrow construction typically given this ground. In making the motion for new trial on this ground, a party seeking relief has the burden to prove that he exercised reasonable diligence to cover and produce the evidence at trial. If the party does not make this showing, the motion must be denied. Moreover, the general averment of diligence is insufficient. The moving party must state the particular acts or circumstances which establish diligence. In lieu, the appellant contended that a new trial should be granted because she only discovered after trial that a previously uncooperative key expert witness was now willing to testify. The court found appellant's newly discovered evidence argument meritless because she failed to explain why she could not have discovered this prior to or during trial. Even where the moving party successfully proves the requisite exercise of diligence, the party must also show that the newly discovered evidence is material in the sense that it is likely to produce a different result at the trial. Sherman v. Kinetic Concepts, 1998, National Elevator Services v. Department of Industrial Relations, 1982. How might a party demonstrate the requisite materiality of newly discovered evidence? 10. Note 10. Accident or surprise. The courts applied this ground quite narrowly to preclude a new trial based on mistake, inadvertence, or neglect by a party or his or her attorney. For example, in re marriage of lieu again. 11. Misconduct during trial. Misconduct during trial, either by the jury, judge, or opposing counsel, is often asserted as a ground moving for a new trial. See the Sabella case that we read for attorney misconduct. Lewis versus Bill Robertson and Sons, 1984. Improper commenting on the evidence by judge in jury trial. Krause versus Graham, 1977. Jury misconduct. Any irregularities which deprive a party of a fair and impartial trial may constitute grounds for a new trial under CCP 657-1. Note 12. Impeachment of verdict for juror misconduct. Code of Civil Procedure, Section 657, authorizes a new trial where the substantial rights of a party are materially affected by misconduct or irregularity in the proceedings of the jury. CCP, Section 657-1 and 2. Evidence Code, Section 1150A, quoted below, imposes a fundamental restriction on the impeachment of a verdict for juror misconduct. Upon an inquiry as to the validity of a verdict, any otherwise admissible evidence may be received as to statements made or conduct, conditions, or events occurring either within or without the jury room of such a character as is likely to have influenced the verdict improperly. No evidence is admissible to show the effect of such statement, conduct, condition, or event upon a juror, either in influencing him or assent to or dissent from the verdict or concerning the mental processes by which it was determined. A. The basic objective-subjective distinction. B, C, D. The objective-subjective distinction and deliberate error. E. Impeachment for reliance on juror expertise and other outside evidence. I am highly inclined to skip those sections. F, G, juror inattentiveness. H, presumption of prejudice when jury misconduct proven. I, juror misconduct during voir dire. J, no knowledge declaration. Highly inclined to skip 2 full pages about jury misconduct because, frankly, we're not allowed to talk to the jury. So I really don't, the jury has to come forward and say something went wrong. So the circumstances in when any of these things are going to happen is highly unlikely. But I'll give you the cases in case something like this happens. People versus Hutchinson, 1969. Maple versus Cincinnati, 1985. That has to do with the basic objective-subjective distinction. UC Trammell versus McDonnell Douglas Corp. When there's a declaration of a foreperson admissible, which evidence a discussion among the jurors to inflate their verdict or to compensate for attorney fees or income taxes. Come on. In which the juror declarations were properly admitted, or affidavits from several jurors admissible. Okay, so that D. Rosario versus Havens has to do with juror declarations held inadmissible. Maple versus Cincinnati relates to reversing a new trial order because the trial court improperly admitted jury declarations. There's 2 cases within the objective-subjective distinction and deliberate error. This first deliberate error is demonstrated in some jury subjective reasoning process where there was misunderstanding, misinterpretation of the law in Mesher versus County of San Diego, 1982. Several juror declarations which essentially stated that jurors used definition of battery in the deliberations, which was more favorable to the plaintiff than the trial court's instructions held. Inadmissible. Ford versus Banaka, 1995 juror declarations that showed jury misapplied concept of comparative negligence held inadmissible. Interesting. So I'm really confused why they're evaluating it on the grounds of admissible and inadmissible. As to the new trial? As to the decision to? move for a new trial? I have no idea why it's being defined in terms of evidence. Anyway, for impeachment for reliance on juror expertise or other outside evidence, there's the Glage versus Hawes firearms case of 1990, in which the juror's reference to a dictionary for the definition of a term used in the instructions constitutes misconduct. Ellsworth versus Beach Aircraft Corp., 1984, new trial properly denied for wrongful death against manufacturer in light plane that crashed, where submitted declarations stated two jurors had remarked that they had watched shortly thereafter commencement of deliberations that led to large verdict for plaintiffs, a television broadcast of a program criticizing the safety record of light aircraft. Alright, so these jury declarations might actually be how we determine juror misconduct, because like I said, attorneys aren't talking to them. They're giving these declarations. I don't know why. Maybe in special verdicts. McDonald versus Southern Pacific Transportation Co. of 1999, in an action by a train brakesman for injury suffered in a train yard. Trial court erred in denying plaintiff's motion for a new trial, where a juror declaration stated that another juror, a professional transportation consultant, commented at length during deliberations as to why the plaintiff's theory of how due care could have made his workplace safer was unrealistic and impractical. Lankster versus Alpha Beta Co. That person should have been removed from the jury. So, by virtue of what he does for a living. Independent investigations by facts by juror constituted misconduct. In what again? In the Lankster versus Alpha Beta Co. Now we've got Compare University of Los Angeles of 1999 for jurors that relate their personal experiences during deliberations. And compare that with Iwekwo versus City of Los Angeles of 1999. That's IWEKAOGWU. After affirming denial of defendant city's new trial motion in an employment discrimination action, where the juror declarations revealed that during deliberations, one juror gave emotional descriptions of instances of discrimination he had seen as a reserve police officer. Juror inattentiveness is demonstrated in Hassan versus Ford Motor Corps of 1982. They're drinking alcohol, apparently. Surprise. That's actually a surprise. Presumption of prejudice when jury misconduct proven. Again, we're going to Hansen. I wonder why. Juror misconduct during voir dire is exemplified in Weathers versus Kaiser Foundation Hospitals, when there was intentional concealment of racial prejudice against plaintiffs and bias in favor of defendant. Hospital held misconduct. Wiley versus Southern Pacific. See, like here they're saying held misconduct, which means is synonymous, I think, with inadmissible. But like, I don't know why earlier they were using admissible and inadmissible, and here they're able to say misconduct, not misconduct. But I didn't read it either. I'm just going through the cases. We also have here Wiley versus Southern Pacific Transportation Co. for the juror misconduct during voir dire, in which there was intentional concealment of juror status as the defendant in similar lawsuit held misconduct. Tapia versus Barker, concealed prejudice against plaintiff's Mexican background and against awarding damages for pain and suffering, both of which were biased as the jurors had denied on voir dire, constituted misconduct. And Smith versus Koval was of 1980, a juror's silence concealed his bias against high verdicts. I don't think that should be right. That should not be enough to turn over a case. But no knowledge declaration. Because, like, how would anyone know? I don't know. No knowledge declaration is exemplified by Weathers v. Kaiser Foundation Hospitals, 1971, and Wiley v. Southern Pacific Transportation. What does no knowledge mean? A party who moves for a new trial on the ground of juror improprieties must file a no knowledge declaration which states that neither the attorney nor the client was aware of the alleged misconduct prior to the verdict. That's interesting. Alright, note 13. Federal court grounds for new trial motions compared. Rule 59A of the Federal Rules of Civil Procedure authorizes the federal trial judge to grant a new trial for any of the reasons for which new trials have heretofore been granted in actions at law in courts of the United States. This broad authority permits a federal district court to order a new trial on grounds such as insufficiency of the evidence to support the verdict, excessive damages, newly discovered evidence, misconduct of juries or opposing counsel, and other prejudicial irregularities in proceedings. That's wonderful. Okay. A. The federal district courts commonly employ some variant of the verdict against the great weight of the evidence standard. Okay, highlight. Yes, they did. Verdict against the great weight of the evidence standard when determining the insufficiency of evidence to support the verdict. From Eyre, EYRE versus McDonough Power Equipment, Inc., Fifth Circuit. The District Court of 1985, the District Court empowered to grant motion for new trial when verdict is against the great, but not merely the greater weight of the evidence. Brown v. McGraw-Edison Co., 10th Circuit, 1984. New trial standard is whether the verdict is clearly, decidedly, or overwhelmingly against the weight of the evidence. And they ask, how is that different than the California standard? Alright, what's the California standard again? Unless the manifest? No. For a new trial? The court is convinced from the entire record, including reasonable inferences therefrom, that the court or jury clearly should have reached a different verdict or decision. Versus great weight standard against the great weight of the evidence. You should have reached a different verdict, or the verdict was against the great weight of the evidence. I'm going to say California is more strict. B. The federal courts may also grant a new trial on the ground of excessive damages and may condition this new trial upon a remitteur. See Gumbs, G-U-M-B-S vs. Pueblo International, Inc. of 1987, U.S. vs. 47.14 acres of land. I love that one. See also Irene Sand note, remitteur practice in the federal courts. However, federal judges lack the authority to grant a new trial for inadequate damages conditioned upon the defendant's consent to an increase in damages, because such an additure is viewed as an impermissible invasion of the province of the jury and therefore precluded from the 7th Amendment of the U.S. Constitution. See Dominic v. Schiedt, S-C-H-I-E-D-T of 1935. So I thought that would be respected in California, and it's not. Okay. Note 14. Federal procedures for new trial compared. There are some significant differences in the procedures governing new trial motions in the federal courts as opposed to the California state courts. A party has only 10 days after entry of judgment to serve a motion for new trial in federal court under Federal Rule 59B, as opposed to 15 days under CCP 659. More importantly, a federal district judge has power to order a new trial of its own initiative within exactly sua sponte. They do have the power to order a new trial on its own initiative. That's why I paused before. I was like, oh my god. Within the 10-day period. Rule 59D FCRP. When a party has made timely motion, a court may order a new trial for a reason not raised in the motion. In such circumstances, Federal Rule 59D requires the district judge to specify the grounds upon which a new trial is granted, although apparently with less particularity than CCP 657. I agree with that statement. Which requires the state court judge for new trial orders generally. See Greeleyland v. Lyons, 9th Circuit, 1960. Sounds familiar? That's Grill, land. As a general rule, no reasons need to be stated by the trial court in an order granting a party's motion for new trial. Unlike the 60-day period and CCP 660, Federal Rule 59 does not impose anything like that. So California, again, is going overboard.